Hello and welcome to another edition of Finsec podcast. We call it Decoding with Finsec. In this episode, me and Sandeep are going to discuss the tenure of the outgoing chairperson, Madhabi Puri Buch, the tenure of the incoming new chair, Mr. Tuhin Pandey, and whatever big events which have happened in the past 3 years tenure of Madam Buch, and what is expected out of Mr. Pandey's tenure. So Sandeep, welcome to the podcast. This is a new and start of new financial year. All of us are excited. We're shooting this podcast on the 1st of April 2025. And it's a beginning, it's an end of an era, start of a new beginning. We have ended the last financial year. We're starting a new financial year. We have ended the 3-year term of Madam Buch. We asked 6 years. She was 3 years a full-time member and 3 years at the helm of SEBI. And the new chair has just taken the position. So let me just start with how do you see Madam Buch's term? 3-year term, she broke a lot of glass ceilings. She was the first lady chair, first whole-time member. She was lady first. Then she was the first private person to come at the post of whole-time member and then to become a chair. And for first time we had a combination of a finance minister, a lady, SEBI chair, a lady. And it was a good 3-year tenure for her, and long enough I had met the SEBI whole-time member, etc. So I would like to understand, how do you see like top 3 or 4 or 5 achievements that she's able to bring in SEBI in her tenure? As in, things that can come top of my mind is like T+1 settlement. That was, people said can never be done. She did it. Then this whole issue of industry standards. She created this industry standard forums where CII is now making laws in terms of companies, how disclosure should be made, what related party transactions, what information should be shared with the audit committee, etc. Basically, even for portfolio manager, investment advisor, research analyst, and other market intermediaries, brokers. She has used the Brokers Association in the RIA associations, CII as a forum to make the laws. We have not gone the SRO route because you understand SRO is slightly more complicated, but she's taken a middle path of using the industry standards. And third, I think the big one which I want to start off also seek your views are on the secondary market reforms. I think there are a lot of reforms that she brought in from after the Karvi debacle, when she said, over my dead body, anything like Karvi can happen again. So she ensured that the segregation of funds from brokers to clients. I think we can safely say India is one of the safest market vis-a-vis secondary market transactions. The risk of brokers being broke, infecting the common investors, have reduced considerably. So these are I think I just wanted to start with how do you see her tenure, what are things she has achieved, and what's the report card?
Great, thanks Anil, and I think it's obviously the interesting times to be discussing this firstly, looking at the market today and all the tariffs, the impact on the markets, and I think overall it speaks to the first and last question you raised, which is systemic safety, speed, etc. And I think that's one area where I think the outgoing chairperson has had made a significant contribution. I think people underappreciate how well the T+1 system really works. And we happen to be probably the first country, maybe second country in the world which has actually implemented T+1. And what it really means for the average investor is that you get your money the next day, as opposed to, when I grew up, when I graduated from law, it used to take several weeks, if not several months for the, including the postal delays for the share to come back with the certificate form, etc. So moving to this is, not just fast, but it's also much more efficient. And when I say efficient, I mean that the risk in the system goes down. Every time you have money, securities kind of hanging in the air for 3 days or 4 days, the amount of risk is X, and the shorter the cycle it is, the less the risk there is in the system, because you owe somebody money for a shorter period of time. So not only do you get the money quickly, but the amount of risk in the system goes down. So it's actually a great system. Why didn't we think of it earlier? Because the entire system has to become more efficient. Banks have to deliver money quickly. The clearing corporation has to calculate the risk metrics accurately. The securities have to flow from the demat account. So, lots of moving parts, and everything has to be synchronized to go from, whatever T+3 system to 2 and then finally to 1. So I think that's a remarkable kind of achievement, and credit not just goes to her as the chair, but also to the entire system, including clearing corporation, depositories, and the banking system.
And the broking system.
And the broking system, which made it possible. This also connects to, the whole point of not having a Karvi again. And I think that's also, again, we can't prove or disprove that fact that Karvi will not happen again. But I think significant changes have been made in terms of enforcement of the current rules. Again, the rules are not new. If you go back to why Karvi happened, actually in 1999 circular onwards, there have been rules which say that exchanges have to actually supervise brokers every single month. It used to be every quarter, then it became every single month. It's just that the rules were not properly enforced. So it's too early to say that that we should start congratulating ourselves that Karvi will never happen again. But I think at least something similar will hopefully not happen in the near future. But again, goes back to the whole systemic efficiency that we have seen, and hopefully that itself will reduce the kind of latitude brokers have. Again, systems have been put in place to ensure that brokers don't hold on to funds for too long. They need to return it periodically. There has been enabling mechanisms for money to directly go to the clients. Again, it's a choice of the client. But there's less money floating in the system, fewer securities floating in the system, and therefore kind of less risk that your broker or any other intermediary is able to kind of steal money from the middle. And again, I come from a period where theft was very common, especially courier companies or even big registrars were part of scams where they stole money or securities while it was passing through the system. So I think we've come a very long way, and last 3 years I think I would give SEBI a lot of credit for making systems safer, faster, more resilient, and most importantly kind of much safer from fraud.
So coming to this safer market being the theme, how do you react to her whole push on ensuring that the retail guys do not participate in the F&O segment? How splitting of the trading weekly settlement cycle? SEBI, NSE says Monday will not do Monday. Then they will say Monday, Wednesday, Thursday. So each week becomes trading cycles, end of trading cycle. NSE last week said I will not do it Monday, or will do it on Monday. The BSE stock price goes up 10%. So idea is that once you come up with a circular to say that I want to curb retail participation in F&O trade because 98% people apparently make losses, and accordingly and also the whole proposition is that a lot more trades happen on the expiry date, because that's where the whole circle happens, and culmination of trade cycles, everyone trades on that date, and you wanted to curb those trading days, and that's why you said one exchange one day, and therefore then 2 exchanges are there, then 2 days, the 2 more exchanges will come 4 days, 5 exchanges will come 5 days, and 10 exchanges come in. How do you ensure? That's the point is, how do you see SEBI's push, whether there are 10 crore people who uses Dream 11, 2 crore people use demat accounts, and out of the 2 crore, how many people do F&O? I'm not know statistics on that, but point being, is it fair for SEBI to over-regulate, or is it over-regulation to become a nanny state as to how retail should use their money? It is their hard-earned money, how they want to use it. Unless you say it's illegal. Say F&O is illegal, of course I can't do it, you can't do it. Betting is illegal, I can't do it, you can't do it. If it is something which is accessible to everybody, why should there be more curbs on increasing it, like top ticket size, etc.? How do you protect retail from F&O?
So I think you kind of raise a very important philosophical point before you get to the question is, what is the role of SEBI really? And it's pretty important to kind of recognize there's a distinction between a regulator trying to remove ignorance from the market and a is trying to remove stupidity from the market. I think the job is to remove ignorance and not stupidity. And in fact, SEBI came out with a study, which is the right way to do it. They said 89% of F&O traders are actually losing money. And sure enough, they did another study 1 year later, and the number had climbed up to 93%. So I think the role is to really educate people that this is not working for you. Here are the statistical numbers. It's a bit like, every time they do a survey of how many people think they drive better than the average, and apparently 85 to 90% people, this is across countries, say that they are actually better drivers than the average. So I think people clearly overestimate their ability to play well in the markets, and I don't think it's SEBI's job really to kind of ensure that people don't lose money. They can make it they can certainly calibrate it a little bit to the extent that make it for bigger players, because I think we are a very retail market. Globally, I think it's very few markets are retail in the F&O space. So I think we can do some calibration with respect to allowing kind of big boys to play. But beyond that, I don't think this whole business of setting expiry dates and coordinating, and actually a whole new exchange being set up to create an arbitrage of these expiry dates. So I think it's quite pointless. And in any case, it is pointless because I think the peak of this whole F&O boom is already probably we're seeing in the rearview mirror. I think as markets deflate with all the volatility, etc. Anyway, I think the market is going to shrink quite dramatically. So I think really what you're doing is you kind of shutting the stable doors after the horse is bolted. So I'm not very sure that it's going to be useful even from that perspective.
Sure, I think volumes have gone down. All the statistics show that people have started trading less. But I think the overall impact, if you have to see, again, I'm going back to the Dream Million example. Was there a study done in 10 crore Dream Million accounts, how many people are making money or losses? Was there any study done on how many people are making money or losses in mutual fund, for that matter, or for that matter in direct equity, buying single stock, not doing future and option? See, point is, any study to be done in isolation and to come a conclusion that this thing is good or bad for anybody is not the job of the regulator.
Yeah.
And even from the point of view how we saw as to there was a bubble in small cap was of course a famous statement given. So what is the role of a regulator? Is the role of a regulator is a nanny to say that no, I want everybody to make money, and that is the whole purpose of my existence, and people should trade only where they can make money. If it was money making was so easy, then everybody should stop doing all industrial work, everything, and stop only do trading. And whole philosophy of trading on the stock market is it's a risky business, and whole disclaimers that are paid. And point is, once a market is functioning in terms of rules which are governing, it's the regulator's job to then micromanage to say that who can trade. No, if you should have a net worth of 10 lakhs, then only you can trade, or to say that this is the minimum ticket size you should trade, otherwise you should not trade. Where should this over-regulation, and that's come to the theme of the point, the second thing that we want to cover is to how you see the tenure in terms of the shortcomings or things that they could not achieve. Like there were allegations of too much interference in the running of the business, micromanagement, setting rules for every comma, full stop. I think there were discussion paper more than hundreds in number, more rules and regulation, more discussion papers were issued. For one time we had 5 discussion papers only on AIFs. So where I'm coming from is how did the tenure go in terms of whether the SEBI regulatory framework, did it become overburdening the players, where there was 5 consultation paper going on one industry, the industry doesn't even have time to react to them, and the laws will come out. So how do you see even from the new chair's proposition as to how he should approach the regulating SEBI and the whole over-regulation, which is alleged over-regulation, which because of the kind of consultation paper, kind of rule-making. I think there's several rules which were made for every single thing. I can think of LODR, market rumors have to be verified by listed companies. Then the whole question of what is material, what is not material, whole list has come out. Then even for related party transaction, there's a whole list of items that an audit committee supposed to get from the company. We are making more and more rules which are prescriptive in nature rather than, as they say, one size fits all does not work. Everybody should work on a principle basis, whether whole objective act should fulfill, not like every tick in the box. How do you see, even for Mr. Pandey's tenure, how should he approach SEBI's regulatory architecture?
So I think it's important to kind of point out two issues really. One is over-regulation, and if you just look at the mutual fund regulation and master circular alone runs into 1,000 pages. Just these two sets of law, and that's one industry and just two kind of examples. So clearly we've gone into over-regulation, and it's kind of very difficult to kind of, for even experts, including us, to keep track of daily changes. And yesterday the law is this, now is that. Almost every day we get calls on, do we have to disclose this under materiality policy? So I think over-regulation certainly occurs, but I think the bigger problem is poorly drafted regulation. And I wrote a piece some time back saying that fraud is defined so inaccurately that running and jogging would also be fraud under SEBI definition of fraud, because it doesn't require any of the five elements of fraud which are understood. And I think this goes back to really poor design. We've had the famous Balram Garg case in which a person was prosecuted for insider trading for selling before good news was disclosed, which is the exact opposite of what common sense would dictate. But SEBI said, our law doesn't say that the direction of trading is important, and it took the Supreme Court's basic logic to laugh at SEBI and say that that's not how it works. It has to be in the same direction. So if you're buying before good news or if you're selling before bad news, then it's insider trading, otherwise it's not. So I think poor design, our obsession with words. In fact, the last speech of one of the last speeches of SEBI chairman, she made two mistakes in her speech. If people were to follow that, SEBI would send a show cause notice with respect to what an investment advisor can do. Which also gets us to the concept of investment advisor. They've been so hyper-regulated. Almost every week I see on social media that one person is quitting the profession. And in a country of 1.4 billion people, we have well under 1,000 people registered people, and they're quitting as well. So that number is going down, it's not going up. We've had things like prescription of how much money is payable to investment advisors, when it is payable, how much advance money can be collected, and there's a long period of time when credit cards could not be used for payment. These are all kind of very poorly thought of regulation. So one, you have the problem of over-regulation, and two is just poorly designed regulation which go all over the place, which people don't, even the regulators don't have a handle on. And that's where, if you combine that with the enforcement action where you are incentivizing your employees who are going to inspection to find more technical defaults, it became a recipe for disaster for intermediaries. People are just kind of sick of the whole cynical kind of drafting of laws, and two, the transmission losses of those poorly drafted laws. And finally, being kind of hauled up for every small mistake out there. So I think hopefully that era is gone, and that's probably the biggest negative legacy for the previous chair.
I want to build on that enforcement part of it again. See, what we have seen in the last tenure, also her tenure, and what we've seen from past decade of SEBI in terms of enforcement. What we've seen is there is weak enforcement, in the sense SEBI can't even win their own orders. They lose repeatedly at SAT, be it NSE co-location, be it the Carvey scandal where thousands of crores were taken out of the bank without even the drop of the hat, without even informing them. Even from the point of view of a car co-location, where it was so many crores of rupees were asked from NSE and the brokers, which was set aside by SEBI, SAT, now pending before Supreme Court. And even the famous insider trading cases where Balram Garg, PC Jewelers cases where SEBI found that Supreme Court found there was no case of insider trading. It's not a technical violation. Somebody has traded basis of position of UPSA, that's enough. Doesn't matter whether he wins, loses, doesn't matter. Even from point of view of what happened with the Takano and the Reliance judgment in terms of sharing information. if somebody you've sent a show cause notice, the least you could expect in the natural justice system is that you provide the information that based on which the show cause notice has been issued. So we have been resistant on that also, where they've got a meeting at Supreme Court. So and on the parallel we see in all the famous cases of, let's say, Access, etc., there has been settled. Even for other cases of insider trading and all, we routinely see insider trading cases settling for 15 lakhs, 20 lakhs, 30, 40 lakhs. What do you view also how the enforcement side of SEBI is weak at? One, like Supreme Court committee which was set up with Adani, one of the recommendations of the Supreme Court committee was that people who are doing the quasi-judicial function of imposing a penalty or imposing a non-monetary penalty should be independent people who should not do executive roles or administrative roles or investigation role. So you have a 5, 7, 15 people identified to only do that and do it judiciously and without the bias of investigation. I am the investigating agency and I will be the judge. From the point of view of how the settlements are coming up with such low amounts, where see, the law of economics say that in securities law, what happens is that it's not all cases of insider trading can be traced. It's very difficult to trace insider trading, how much of a good software you have. The problem is that it is 1 in a million trade which happens on a day, and one trade is insider and rest of them are not. So it's difficult to identify that. Very likely out of 10 cases are identified, 9 just goes because it cannot be identified. So in these cases where the offense itself is difficult to identify, therefore the law and economics say that the punishment should be extraordinarily high. If only 10 out of 1 person is being caught, the punishment will be so harsh that the 9 people are determined to do it. But in what we have in the past 5 years, we have seen how SEBI has approached cases like insider trading and front running, etc., which are basic, the 1 or 2 top level crimes that in securities law can be fraud and insider trading and front running, which is like murder, rape and dacoity in terms of criminal laws. These are the top 3 crimes. SEBI has been of late either settling at a very low number or even penalties are like 5 lakh, 10 lakh, 15 lakhs, bar for 6 months, 1 year. No deterrence. I would do insider trading 100 times and get caught on only pay 2 to 5 times and still save 95%. So from the enforcement point of view, what should be the new chair's this thing? A, splitting quasi-judicial this thing. B, strategy of settlement. Then C, what should be the approach of how should SEBI enforce its power? We have a lot of powers. It has more power than SEC has. So how do you see the enforcement part? Where do you SEBI should go?
So I think on the first point of separation of the judicial wing from the other wings, I think people have been saying it for 20 years now, frankly, and I don't even want to discuss it too much because people agree with it, but nothing really happens. So I think it's pretty pointless to discuss it today, but I think it's kind of an accepted wisdom that it should, whether it sits outside of the SEBI bhavan or inside, I think it should be kind of segregated, and I think most kind of commonsensical views agree with that. That will also address the point of not having the objectivity to decide those cases, which is exactly what ICC does. They typically don't decide those cases in-house. I mean, they did get the powers more recently, but broadly they have to collect all the evidence and present it to a district court in Washington DC, which makes it kind of they really need to work hard as opposed to India, where SEBI is the judge, jury, and executioner. And normally when you go for the hearings, you realize that you're really giving a monologue. There's no other side because the judge is really the other side, which makes it very awkward and odd, not just optically but also from a fairness perspective. So I think, but like I said, it's not happening anytime soon, so I don't want to spend too much time on it, and it is accepted wisdom. In terms of penalties being too low, I don't think that penalties are too low. Again, I think the problem goes back to design. We have created probably the only country in the world which has all these deeming provisions that you deem to be insider so long as you connect to another person. My own example, 99% of my LinkedIn connections, I have no idea who they are. So you create all these deeming provisions where you're connected. I may be providing some legal advice on a very narrow set of, whether something's material or not. But I'm deemed to be connected to the company, and I'm deemed to, that the legal head passed on quarterly financial numbers to me if I buy 100 shares of that. And there's no de minimis number as well. We've seen examples where SEBI has gone after people for a few thousand shares. In fact, many cases. So once you create these laws which are in a way perverse, we saw the case that we mentioned, Balram Garg, where somebody who was selling before good news was prosecuted, had to go all the way to the Supreme Court. In fact, SEBI filed a review case after that. Instead of apologizing to the people, they filed a review case. So I think when your laws are so poorly designed, you catching and again, based on my own experience, I don't know if you share the experience, but I think a lot of innocent people get caught up with these poorly drafted laws. So people who have not done insider trading are kind of hauled up. And for them, I think the question is, when you have the judge, jury and executioner who's going to be deciding your case, there's a good chance that even though you're innocent, you're not going to go away scot-free. Which brings you back to the settlement mechanism. Might as well pay the settlement amount for what you think is a lower number. But it's according to me, it's an astronomical number for a person who's innocent, who just wants to get rid of the nuisance value of the SEBI being out there with the case files, which they don't share despite 2 Supreme Court rulings of Takano and Reliance. Weekly we see they refuse to share the entire inspection report. You have the same person, not exactly the same human being, but pretty much the same set of people who are doing the investigation and acting as sending you show cause notice and being the judge and jury. And punishing you at times up to 3 times the gain made or 25 crore rupees. So I think it's a lot of money for most cases, especially in cases where I think a person is kind of caught up with deeming provisions. And again, I specifically mentioned insider trading, where you have a whole host of people who are deemed to be connected to you. I mentioned fraud earlier, where the definition doesn't require even a single of the 5 elements of fraud as we lawyers understand it. So I mean, if you have such kind of very, very, and they're not kind of broadly drafted laws, they're just poorly drafted laws, they're catching all kinds of random conduct as fraud or insider trading. So till the time we solve for that, I don't think enhancing penalties is actually a solution.
I'll tell you why we say enhancing penalties is a solution. The point is, what you've seen is that you have to look at SEBI from a 2 point of view. There are technical violations which have to be ensured that you impose penalty on that. Let's say disclosure, non-disclosure of material label. Let's say insider was traded or not disclosed to the company. These are part of the information system. The securities market is based on the philosophy of market efficiency, which ensure right information at the right time is provided. And therefore, any kind of infractions on that also should be, of course, penalized. Otherwise, there will be an issue of people being indisciplined and not following the law, and therefore the efficiency of the market will go down. So that has to be done. So therefore, the whole, how does the US does it and all, they have FINRA, etc., just SROs who are concentrating on the low ticket issues, which are compliance centric. Where the compliance centric issues could be easily be outsourced to the SROs. And SEBI as an organization should work more on the big picture, the rape, dacoity and murder, the insider trading, the front running, the frauds in the market. And that's where you have to have more penalties. Point is that if you see 1992 was the SEBI Act. SEBI Act was framed at that time, the penalty was 1 lakh per day up to 25 crores. Are we dealing the same reality of 2025, wherein even for a large fund, I'm saying a large listed company, paying a 5 crore, 10 crore penalty is not too much. If you are making 100 crores, 1000 crores a year, 5 crores, and even for people in the sense of having a deterrence of somebody who's done insider trading, if you're getting scot-free by paying 50 lakh of penalty, I'm sure the net worth of that person will be more than 5 crores easily. What is the deterrent? And as you said, how people who are doing settlement, innocent people have to do settlement. A lot of guilty people are getting in the garb of, because now the public sentiment has people become people who are innocent also settle, and therefore guilty people also settle. Nobody understands who's guilty, who's innocent. When they settle, pay some money and get out. So that is why I'm saying, even what has happened, if you see the GDR cases, etc., where SEBI later on decided let's increase the penalty, this 5 lakh, 2 lakh is not good enough for somebody who's done some fraud. They increased to 25, 50. But what happened at SAT, because SAT level, what happens is then SAT says no, in previous cases you have post 5, you cannot put 50 here, and therefore you should increase. So you cannot increase. And that is where the SEBI as an enforcement authority also has issues of how to increase penalties now. And that's why I think it's to the government of India to make some amendments in the SEBI Act to ensure that SEBI goes for the big picture and have harsher penalties so that this does not happen again. B, huge deterrence, because only way you can enforce security law is deterrence. You cannot prevent it by surveillance. It can never be prevented by surveillance. It can only be done by punitive action, by putting more sanctions. And that's why SEC operates. Look at them, this thing 5 million, 10 million, 15 million is minimum for settlement, or any penalty is huge. And people go to jail. Nobody goes to jail in India. I have never seen that. So my point being, settling from SEBI Act has to be some, like that comes to the new code. One of the budget discussion was that SEBI will have a new code, Securities Law Code, which will bring in all this Depositories Act and the SCRA and SEBI Act under one roof. Therein they can now bring in those features of SROs can be created, and even for big ticket items, separate penalties should be imposed so that these are big items which should not go lightly. And how do you see this Securities Law Code and having this sector enforcement administrative matters, whether the Securities Law Code will solve the purpose? You think that is something which is desirable?
So let me come to your last question first. I think the code would be useful because I think a lot of the stuff which was drafted in 1956 is completely redundant, including suspicion of speculation and stuff like that. So hopefully it will come someday. It's announced in the budget, so I'm assuming that it will come at some point. With respect to, again, I don't completely agree with the quantum of penalty. I think it was amended and now you have 25 crores or 3 times again made. And, we've had examples where very large sums, including hundreds of crores, have been imposed on people. But I think before you even discuss that topic, I think 2 things have to be discussed. And first is what I already spoke about, which is poor design of the laws, overbroad deeming provisions, poorly drafted. The US is able to catch fraud at a much better scale with 150 words. It's literally just 150 words, whereas we have drafted 24,000 words worth of law against fraud and insider trading. And if you were to ask me, are we vastly superior? The answer would be no. We are vastly inferior to the quality of drafting because, and again, with 150 words, they are able to kind of catch the same people with the same kind of laws. They don't have wiretapping laws there either. So, what are we doing wrong? I think 2 things. One is, I think, poor design, and 2 is, I think, the scope of work that we take on. If every violation, like you have said about FINRA, should take care of the low technical violations, etc. We don't do that. We kind of prioritize fraud at the same level as somebody filing a report 3 days late. With the result, we have thousands upon thousands of pending cases, which cannot, I think, last I calculated, SEBI, if without the consent route, SEBI would take upwards of 15 years to dispose of the current cases. So, if you take on every single violation as, you take kind of a very enthusiastic view of those cases and say, okay, I'm going to do a full investigation of that. Why was that report filed 3 days late? Send a show cause notice, call the person for a hearing, file a reply, hear him, pass an order, then maybe go in an appeal and spend years trying to dispute that. I think either they should create an SR which looks at those technical violations, or they simply kind of send a warning letter and say, please don't do it in the future, we'll take a more serious view of that. And I think 95% of all cases can really fall into that bracket. I think what would really remain would be fraud, insider trading, takeover violations. I think everything else can just be done by way of, just a short order saying that, we've taken a serious view of it and be careful, we're watching you. And that should solve the technique. Again, mistakes happen in any organization, and every time you do due diligence, you realize mistakes run into sometimes dozens or hundreds of instances over a period of time for a listed company, and that should not be the metric for kind of penalizing companies. If it's a deliberate kind of or egregious behavior, certainly yes, but beyond that, I think we kind of spreading ourselves too thin as a regulator when you go after every violation that you can put your eyes on. But again, it goes back to that they're scared of CBI coming after them and all that. So again, that problem is to solve from that angle as well. That provide some kind of a defense to the employees of SEBI that when they see a violation, they should be able to kind of just send a warning letter and not launch the nuclear codes.
So let's finish this conversation. 2-3 key goals that you think the new SEBI chair should have. Like we discussed just before when we started the podcast. One was your views on the promoter reclassification as to how the significant shareholders, why should they be called promoters? Why should startup promoters should be called promoter and should give up ESOP? All those things, that new consultation paper is also out. And on the issue of now FPIs, how there should be liberalization in that front. Now, yesterday itself we saw a paper, or at least a report on news talking about the direct market access to foreign clients, foreign investors can come directly, and let's say we as Indian people can buy Apple stock through this through this international brokers just by LRS transferring money and buy the securities. But US investors cannot similarly buy Indian companies. They have to go through an FPI and then only they can buy. Or if for that matter, if not direct FPI, then they'll have to take P-notes, etc. And therefore that has become much more complicated. Easy entry and exit is not there for foreign investors. Is it something that can boost up a lot more capital can come in India, where you provide it up to a limit of, let's say, 1 crore, 2 crore, whatever SEBI feels right, and then give them the access, provided the KYC and tax consultation that you can give.
No, so on FPI, I think it's a great idea to provide direct money. I think we've created this whole framework of having an FPI for foreign investors to invest. I don't think it's required at all. Even for global FPIs, I think we have privatized it, of course, the registration, but still I think it can be made much easier for investors to invest in India, including, very few people know that we've allowed individuals to register as FPI, so it's kind of a well-kept secret. And it's been around for at least 15-20 years now. But since nobody knows about it, individuals don't register as FPIs.
No, even it's a big deterrent. If you ask me if I have to invest in US, they ask me, you please register yourself as a FII there, then only I'll not invest, because who knows, they will put me some show cause notice on my, how do I know?
Plus, if you want to buy 50 shares of Apple, you're not going to register as some entity.
And also the compliance also have to do. And cost.
So the nuisance value itself is large enough. So I think it's a great idea, number one. In terms of just kind of the big picture, I think for the new chairperson would be, I think, just looking at all the laws, simplifying them, getting rid of deeming provisions, right sizing them, not just kind of, make sure fraud has the element of the 5 elements which are needed to prove fraud. And then figure out your capacity and, do enforcement cases based on that capacity. And I think a lot of things will fall into place if these simple design metrics are used. And today we have AI, we can actually simplify laws with, with help from specialized AI tools, and it's not such a big stretch. And then, of course, like a couple of other things that we discussed, creating an SRO, making sure that there's significant deregulation, making sure that the separation of the judicial function from the other function, etc. So I think a lot of these are actually not very tough to do. Many would require, including the segregation of judicial, would require statutory amendment, but almost everything else doesn't really require any statutory changes. So I think it's easy to do. And finally, I think on the question of promoters, I think it was announced, I think if I remember right, in 2021, that we're going to do away with the concept of promoter. And it's actually a bizarre kind of relic of the past. I don't know who came up with it. But essentially, if you think of it, it is a departure from the concept of a company being a juristic entity. You're saying not only am I going to hold the board of directors for any wrong, I'm going to go behind to who the shareholders are and hold them up, which is kind of the exact opposite of what, why limited companies were set up 200 years back. We call them promoters, and some intermediaries we call them sponsors, but the concept itself should be done away with, because you want the company and its top management and directors to be responsible and not shareholders. And it has, you think it doesn't have a cost, but it does have a cost, because there are second order impact in terms of who's willing to be a promoter. Second order costs include people being forced to become promoter group, what we defined as relatives.
Second order impact becomes related party transaction. Second order impact becomes the ESOP classification or not. Second order impact also becomes liability in terms of any violation of any material misstatement.
And you have two relatives fighting with each other, you're calling them acting in concert and running the company, whereas one has filed litigation. So we've had all kinds of absurd consequences. I think they should, in fact it was decided by SEBI that to do with it. It's quite surprising their decision of the board has not been implemented, and I think that should be the first order of the day, getting rid of the complete word promoter or sponsor anywhere that is used by SEBI, and let the entity and its senior management and its directors be responsible for the actions of their entity or the company.
Even after this PMLA, each and every single company has to identify individual SBO. A significant beneficial owner, anyways you are identifying a person. Then you are saying identify somebody as promoter, then somebody identifies KMP. There's so many things that SEBI has, and there are a lot of, anyways from after the KYC and requirement and SBO requirement declaration under the MCA, you can still trace back the individual behind the company.
Yeah.
That has been done through PMLA. So this whole purpose of individual behind the company is no longer relevant in the context of SEBI identifying its own. Sometimes the SBO is different and promoter is different, which goes beyond the rationality of why are you identifying such people. So I think that's a great suggestion. Let's see how SEBI goes through it. I think that's about for today. I think we had a great session, and thank you for everyone for joining in.
Thanks.
And we'll catch up with you next time.